Hello, good afternoon. This is Evan Way with Crow and Dunlevy. I am glad to have everybody here today. We will wait about another 10 or 15 seconds to get started for today's webinar, just to make sure everybody's online. I have Stephanie from our marketing department here today, so if you hear me say, Stephanie, pull up our polling questions, or if I turn and I'm looking, I'm asking Stephanie something to make sure all the attendees and that our communications are working this morning. How many attendees do we have?
82 right now.
Okay. Ready? Like I said, my name is Evan Way. I am an attorney at Crow and Dunlevy and a member of the firm's Labor and Employment Practice Group. Today, I'll be discussing USERRA, also known as the Uniformed Service Members Employment and Reemployment Rights Act. USERRA has kind of come into light in this past year, not that it's an unimportant statute, but with COVID-19, the president gave authorization for a number of governors to activate the National Guard in response to the COVID-19 pandemic. And because of that activation, we had a number of employers reach out to us and ask what needed to be done as far as USERRA protections in general, state active duty, and the economic hardship that many employers are facing if they could implement RIFs or furloughs. So those are going to be the three topics I cover today: is an overview of USERRA and how it applies generally, how the 5-year rule applies to USERRA, what type of orders count towards that 5-year rule, have a uniform service count towards that 5-year rule, state active duty under Oklahoma law if somebody is ordered to state active duty, and also how you need to treat service members if there's a RIF or furlough that an employer must implement. Okay, to start with, we're going to have a few questions just because I want to know where the audience is at. So Stephanie, if you could pull up polling question number 1. As I said, we'll give about 30 seconds for each poll. So if you haven't voted, please do so now. All right. So about 80% of our attendees today have service members or employed for them. So thank you for supporting the uniformed services and employing service members. As a service member myself, I'm always happy to see that. And I know we have a heavy concentration of military members in the state of Oklahoma, so it's always great to see employers reaching out to employ them. And I'll kind of give my public service announcement. Employing service members is always nice because you're getting somebody that has passed a background check, has a security clearance, and has essential, skills within their area. So thank you again, employers, for bringing those service members on board. Okay, Stephanie, will we bring up polling question number 2? And again, I'll give you guys 30 seconds to answer. Okay, and the reason I ask this is some employers are always looking for special outreach, and there is outreach out there. We have our ESGR, which I'll talk a little bit more at the end of this presentation, but that's employer support for the Guard and Reserve. And they'll host special events that just have veterans and people that already have those essential skills that you may need, so that it'll save on training and retraining efforts that an employer might otherwise incur to have those individuals. One great example is we have a very robust aviation industry in Oklahoma. And there are a number of schools that, you have a service member that is an aircraft mechanic on the military side, but they're also a civilian aircraft mechanic. And the civilian employers can really benefit from that experience, that knowledge, or the licenses that they hold on the military side for the civilian side. And last, Stephanie, will you bring up polling question number 3? Okay. As indicated, it looks like most of our attendees today are familiar with it, so I apologize if I'm going over some information you already know, but hopefully I touch on some stuff you haven't heard before. And like I said, I'll get into more of the nuances of the 5-year rule and what actually counts. I have copies of official military orders to show you so that we can kind of go through it together and decide what counts and what doesn't count. Also about the intersection with state active duty, since that's not always covered. Since we are on a Zoom poll today and I can't see you, if you have questions at any time, there is a question box you can do, and Stephanie's going to be keeping track of questions. So if it's something very important, we'll answer it during the presentation, but we'll also have time set aside at the end. If you have questions at any time, though, I encourage you to type them in. That way, Stephanie can compile them and pass them over to me so that I can answer them at the end. I know there's a function on Zoom where you can raise your hand. We're not currently monitoring that. So if you raise your hand, just type it in as a question about what it is. And we have keep it generic since this is an open environment and it will be posted on YouTube. So if you have specific questions that are just for you, make sure that you don't divulge any type of confidential information that would otherwise be more appropriate for an attorney addressing one-on-one with an attorney-client relationship. Okay. So to start, the Uniform Services Employment and Reemployment Rights Act, codified in 1994, but really it's a carryover from an earlier statute that was there. What it does at its core is it has a clear expression of congressional intent, and you don't see that with every statute. A lot of statutes are passed and there's no legislative history, there's no intent that's explicitly called out in them. It's just the words on the page, and so sometimes judges and people trying to interpret them, lawyers and employers themselves, are trying to interpret what was meant by that. USERRA, though, however, has 3 purposes that Congress specifically put in there. And the first, is to encourage non-career military service by members that are civilians and military. So you're essentially wearing 2 hats. You wear your military hat, you wear your civilian hat. And the purpose of that is there's a debate going on right now of whether the military on the Guard and Reserve side is either an operational reserve or strategic reserve. But regardless of how that debate comes out, the military recognizes that they need that reserve pool. And that pool is there so that if a contingency happens, if they need people for state active duty, if they need something for a hurricane that happens, that you have those individuals that are already trained and ready to go. We're one of the best militaries in the world because we can train our forces so fast, but we still have that time to get them up to speed. When you have Guard and Reserve or individual mobilized augmentees, you already have that pool that's ready to go, fully trained and qualified, and you want to be able to keep that qualifications for national defense. And so that's kind of the purpose that Congress has there, knowing that they need to be able to plus up or flux or surge, and keeping that operational or strategic reserve ready to go at all times is very, very important for the national defense of the country. The second purpose is to minimize disruption to the service members' civilian lives with prompt reemployment. And that means it's going to be hard to attract people to go to the Guard and Reserve if you say, hey, I know you're in the Guard and Reserve, we really appreciate it, but if you have to leave, we can't guarantee that you'll have a job when you come back. It would disincentivize people to want to join it. And it would make it really hard knowing that you could be gone from anywhere from 2 weeks to 2 months to up to 2 years on a deployment, depending where it was, and that you wouldn't have a job when you came home. So that's why USERRA was enacted in part, is so that you had prompt reemployment, which is better for the servicemen, better for their family, better for the community to know that you can count on as employer, you're going to have that individual back in the future. And the third is to prohibit discrimination because of past, future, or current military service. And that's where USERRA really falls into 3 buckets right there. You have to consider USERRA when you're initially hiring somebody. You can't go, well, I'm concerned that they're in the Guard and they're going to have to do, drill weekends and we work weekends, or they're going to have to be going for annual training. If that's the reason you don't hire them, you've engaged in discriminatory conduct, and that's prohibited by USERRA. And the same is if during the term of their employment, you're like, well, this person's always gone, or they're just not around. One of the cases I read was for the Justice Department. They terminated one of their attorneys and called him an absentee landlord because he was gone 40 days a year. That's discriminatory conduct. And it's just because that person has to go out and serve their military duty during the year, you can't terminate or hold that against them. And the third is you want to encourage people that were service members in the past to still come into your organization. Like I said, I think that they bring a vast set of skills and innumerable experience that'll help you as employers. So great to have you, Sarah. One question that always gets asked is, why did Congress decide to lay out these 3 intents so explicitly? Well, I pulled some figures which are a little dated, and we're in an unclassified environment, so I can't pull up to date where everybody is. But right now, or last year in the fiscal year, we had 336,000 guardsmen in the Army National Guard alone. And of that number, around 27 to 30,000 were activated, over 20,000 were deployed overseas, yet another 20,000 getting ready to deploy to backfill that 20,000 that was coming back. And then another 20,000 that had returned but were in this reconstitution time. Because your USERRA time counts from when you're put on military orders and sometimes a little bit before. But you can come back overseas and you may have a reconstitution time. For the Army, for example, I was in Fort Hood this weekend, and they have 2 weeks of mandatory quarantine that they got to do for COVID-19, but they also have to do their post-deployment in processing before they're released. And for the most part, they earn leave while they're on this, so they may take their leave, so they'll still, even though they're on leave, be on a military status protected by USERRA. So that's why you'll see these numbers is as soldiers are going in, soldiers are coming out, and other soldiers are reconstituting from their service. This number doesn't take into account how many guardsmen you've had deployed for national disasters. We've had national disasters in America this year just with the wildfires in California that are ravaging it. The National Guard has played a huge role in evacuation and mitigation efforts there with firefighters and airlift and medical support and anything that they can do to help combat those wildfires. And as part of that, they've reached out to other National Guard units, and those individuals that have the qualifications and expertise have been deployed in support of what's going on over there. Another example from our past from nearly 15 years ago, a little over 15 years ago, is Hurricane Katrina. A vast number of Oklahoma Guardsmen, both Air and Army, deployed in support of that. Took the C-130s down there, took the troops down there, and they were able to help secure that area because active duty military members cannot carry live ammunition, and they can't police that, but National Guard can because they're the state's militia. So when these type of things happen, it was important to have the National Guard down there so that they could do their job, and support the governor and support the people. And it's important to remember your National Guard members always come from the individuals in your community. They're not a force coming from outside and swarming in. They're a force that's, the bakers and the attorneys and the secretaries and everybody that makes up that community is part of your National Guard that supports your 54. So all your 50 states and your 4 territories in the United States. So that's why Congress has that, is that's just the Army. And on the air side, you have 107,000 roughly Air National Guardsmen in the Air National Guard with around 6,000 to 10,000 deployed at any given time. You have 90 wings across the 54. You have dispersed detachments and geographical locations. They're running counter drug ops, rescuing domestic operations. There is congressional money that's appropriated just for domestic operations. So those assets like the Lakota aircraft and the United States can only be used for domestic operations. They're never going to be employed overseas. They're here to support what goes on in the state of Oklahoma. The National Guard on the air side is also tasked with 24/7 security of America's skies. So in response to largely what happened with 9/11, some of these Air National Guard units have been tasked with, making sure that the skies are safe and secure at all times around our borders. So it's a huge mission, and it's something that these individuals are doing on a part-time basis. When they put on their military hat, they're doing that military duty, and rest of the time they're working for you, their employers, and kind of balancing that at all times, keeping their qualifications up on both sides, and essentially doing everything that they need to progress and keep up that military training and everything else, while at the same time trying to progress in their civilian careers as well. So under USERRA, everyone is an employer. It applies to, if you have 1 employee, 2 employees, 15 employees, you are still subject to USERRA, which is different than a lot of other statutes that have cutoffs of like the FMLA or, you have to have, 75 employees or 50 employees within 75 miles. it's going to be different with USERRA. It's going to apply to everyone. And so it's important to keep that in mind, that at all times USERRA will apply to you. And there's no exemption for a professional exemption or a executive exemption like you might see under the FLSA. So you're not going to be able to exempt out an employee because of their status or any other criteria that you might be able to underneath other statutes. So what qualifies as this uniform service that everyone goes on? Well, it's going to be active duty if they're ordered to active duty, or if it's active duty for training, which we often call annual training, which you'll hear the term as, 1 week in a month, 2 weeks a year, which often does not happen anymore. Very few people, they may go to annual training or summer camp, but they're going to have training in excess of that 15, or that 15 may be spread out throughout the year, but that's annual training. They can have active duty for special types of work, for retraining or professional military education. And then they also have their drill weekends, which is going to be 24 days a year on the weekends. Usually on the weekends, sometimes you'll hear something called a super drill or a plus drill, which will be Thursday, Friday, Saturday, Sunday. With COVID-19, the military, just like every other employer, is trying to look at options like virtual drills or spacing drills out. So things that have to be in person, they're trying to stagger these drill weekends so that they don't have 100 people on base at the same time. Maybe they can get the number down to 250 by spreading it out throughout the month. Just like everything else, they're trying to reduce the transmission of it. So don't be surprised if the dates that you had from your service member initially are starting to change and are going to continue to change, because they're a little bit in flux right now, just like every other employer. They're working as well to try to comply with CDC guidelines and OSHA guidelines to make sure that they don't have a high concentration or a super spreader event from that. So one question that often gets asked maybe once a month from some of our clients is, hey, USERRA doesn't apply here because they volunteered to go on this and they admitted to volunteering to go on it. And the short answer and the easy answer is, even if they volunteer, USERRA applies. It's involuntary service or voluntary service. It doesn't matter why they're on that service. So I have to let some employers down that they think they had a silver bullet for why this termination didn't, violate USERRA. And the fact is that even if they volunteered, it doesn't get you out of it. Another question is can USERRA apply to more than one employer? Absolutely. You can have the same employee, you can be paid by one person. An example would be a staffing company. You're paid by the staffing company, but you're underneath the control of whoever that staffing company has you out to. Those USERRA protections are going to apply to both. So if they give notice to who they're working for, not the staffing agency itself, but the individual, and those reemployment rights are messed up, you can still have USERRA consequences. So it's important to keep in mind that you can have joint employer rules that apply where USERRA is going to apply to not only who pays the employee, but who controls the conduct of that employee. Health plan coverage. Health plan coverage is mandatory under USERRA for up to 2 years, depending how long that service member is deployed. So, or I shouldn't say deployed, how long that service member is on uniform service. If it's less than 31 days, then no change. You just treat them like they normally would. If it's more than 31 days, you can require them to pay up to 102% to cover the administrative costs so that they can keep their health care coverage for those 2 years. And as a practical matter, I don't know if you're going to run into that, because when you're activated in the military for more than 31 days, you're going to qualify for TRICARE healthcare, which is a service or a health provider that's available to all service members, and it's at no cost, and it covers their entire family and their dependents. So as a practical matter, I don't know if you're actually going to face this situation. I'd recommend that if you do have service members that work for you, work it out with them and decide, are they going to elect to use their TRICARE coverage, or do they want to continue their civilian coverage for their health insurance? And sometimes some service members may decide that they like it because TRICARE doesn't cover, everything. It's just like any other healthcare plan. It may have providers that they don't want to use, or somebody's become comfortable with more. The provider that they currently have in TRICARE doesn't cover that. But for the most part, I think as a practical matter, most people are going to opt for TRICARE just because there's no charge to the service member for them or for having their family on that as well. Okay. So I said that USERRA really falls into three buckets during your initial hiring phase, during your employment, and during your reemployment. Reemployment is probably the most litigated piece of USERRA that takes place, and the reason it's litigated so much is because you lose that employee, and you may lose them for a long time, and then they come back to request, that they want to be reemployed. To qualify for that reemployment under USERRA, they need to give advance notice of their military service. Now, it doesn't need to be written, it can be verbal. And there are going to be situations where they can't give notice maybe as fast as we'd expect for other types of qualifying leave. And that is because in Oklahoma, there's a detachment for emergency management response, and they have a 90-minute notification. If the phone goes off and it's a certain number and for a certain situation, they have 90 minutes to report. Depending on what time of the day it is or what's going on, they may not be able to reach out to their employer to say, hey, I've been called up onto military service. Now, you hope that they would under all practical circumstances, but that may happen, and that's a real possibility. Another one is that sometimes you're called up and it's called a calm out. There's no communication that takes place, so any types of cell phones, text messages, emails aren't going to be allowed because of an exercise or a real world situation where service members just aren't allowed to communicate with anybody. So that would be a situation where an employer would not be able to reach out. There is a number, phone number that's out there for all the armed services at least, that you can call and see if a member has been deployed, but it's not going to catch up in time to see if those individuals are there. So if you know you have a service member and they no call, no show, it may be because of one of these rare situations. I'd say it'd be the exception, not the norm, but it could be a situation where they weren't able to give advance notice of why they were going on military service, military leave. And I'm going to take a step back really quick. I said the armed services and the uniformed services. USERRA applies to the uniformed services, which includes all the armed services, your Air Force, Army, Navy, Marines, Space Force now, and Coast Guard. But you also have your uniformed services, which is going to include your public health representatives, your public health corps, and you're also going to have your individuals that fall into that. So with the public health piece, it's a smaller component, but it's a component that is very important in COVID-19 pandemic and its fight against it. So you may see more and more people being called up underneath that as well. So keep that in mind, that uniformed services is all-encompassing of not just your armed services. The term is used in other statutes for Civil Air Patrol and your NOAA personnel, but they are explicitly excluded from coverage under USERRA. So your employee, hopefully they can give you advance notice. Very rare what they won't be able to. They perform their qualifying service and then they timely report back. Now, how much time do they have? If it's less than 31 days, it's the next work day plus their travel time and sleep time. So usually you give them a day because they have 8 hours, depending how far away the service was. If they're drilling in a different state and they have to drive home, and drilling's on midnight on Sunday, it may be till Tuesday, but that's when they report for duty that next day. If it's between 31 and 180 days, they have 14 days to request reemployment to where they were. If it's more than 180 days or 181 days plus, they have 90 days to request that reemployment. Again, just like giving notification that they need to go on military service, the request can be written or verbal. So keep that in mind. Okay, and we'll switch from me talking so much and go to another polling question. Stephanie, will you pull up the next polling question? Okay. So it looks like a little more than half of everybody is tracking their service members to see what kind of duty they're doing. Great to see it. I know that we have some HR software out there that's available to track it, that's very good. You put it in there and it keeps track of it for each service member during their 5-year requirement. But, and if anybody has one that they recommend or that they like that keeps track of this really well, please just put it in our comments question box and we'll share it with the group. I have employers keep track of it on Excel spreadsheets, and then like a little under half, they just don't track it at all because it's not an issue at that time. And then if it does become an issue, then they go back and pull it. When a service member does these military service obligations, you're required, I mean, you're not required, you're allowed to ask for documentation of what's taking place. For annual training, it's pretty easy because there'll be an annual training letter that comes out from their commander for drills. Those are usually published a year in advance, so you can see when those are going to take place. And for other military service, orders are published, and it's literally an order from their commanding officer underneath the authority of either the governor or the president, ordering them to active duty. So we talk about the 5-year rule. USERRA gives you protections for 5 years, cumulative 5 years per employer. So if you're with employer A and you do 3 years and go to employer B, it's a new clock for 5 years. There are so many exceptions to this 5-year rule. So I've got some copies of some orders that I can show you so you can actually see. Now these are Air Force orders, not Army orders, but they're going to differ a little bit. So don't rely and say, it's a little different than what my employee gave me. It's because the orders will differ just a little bit depending on the unit or the software that's done it. So right here, and I'll apologize, we had this where I was going to pop it up and show you guys right away, and it turned out to be too cumbersome for both me and Stephanie at the same time. If you can see that, Stephanie, is that available? Mm-hmm. Okay, so that's what an order will look like, and that's just redacted personal information about where it went. But this order right here is under 32 USC section 502F. And what that means is it was a AGR tour that I performed. Active Guard Reserve. Under an Active Guard Reserve, that means that if you have somebody perform a AGR tour under 502F, that time counts towards their 5-year requirement. Important to keep that in mind because there's a number of individuals that perform AGR tours and they may perform them for up to 3 years. That's going to count towards their retirement. Another one that we have is this one right here. And I've highlighted it so it's a little bit easier to see, but that's 32 USC 504 and 505. Again, those count towards the 5 years for that service member. And one that comes up a little bit less often is this one right here, is Title 10. Title 10 USC 12301D. A quick way to keep the difference is if it's Title 32, it's state duty. If it's Title 10, it's federal duty. That's where the pots of money come from, and that's what's going to be done with it. But Title 10, you can still have some that counts because you can't fly overseas on Title 32. This one right here is an order to Antarctica of all places. But because it still will count towards that 5-year requirement because of its 12301D. So easy to keep in mind. Ones that don't count. And they've gotten better about doing these orders. So you can see right there, that's 32. But down here, you'll see that it even makes mention that this is not subject to USERRA's 5-year rule. So I've seen orders change where they're starting to put that in more of them to make it easier for employers, make it easier for the service member themselves to track it. So that was 32 USC 502A. And these are copies of orders you can request from your service members. And again, here's another one. This one is a 12301. And again, it has a specific clause in there saying that this does not count towards the 5-year, USERRA's 5-year service limitation. So that was 12301B. And I have another one right here with 12302 to show you the same thing. And this was for an Operation Enduring Freedom mobilization. So most of the time, these will not be on there, or most of the time, these will be on the orders so that you can see them and you can verify if it counts towards that 5-year requirement. I will tell you, if you're deciding to take employment action, really go through and what I would say fly spec it to make sure that you're going through and you're counting that time down to the T, because sometimes, especially with those mobilization orders overseas for like Operation Enduring Freedom, Operation Inherent Resolve, they're going to be modified. There's many times that they have to stay in country longer. It's cut short. With COVID-19, we had service members deployed during the middle of that, and some of them, had to stay in place longer because we had to wait for a new group to come in. So that's how it goes. Stephanie, will you bring up polling question number 6? Okay. So as we discussed, those orders right there. Yes. As we discussed, those orders right there, half of them were exceptions. Where you'll see some ones that get a little bit odd are, here's a 32 USC 503, and it's not clear which 503 it falls under, but it looks like it's for retraining, and because it's for retraining, it will also not count. And Stephanie, can you go to number 8? Oh, I'm at 7. Can you go to 7? Sorry, we renumbered. Okay, so went through a bunch of orders, went through a bunch of lecture on what counts. Okay, can you show the results? Okay, so let's go through the first one. Drill weekends, UTA weekends, they do not count towards the 5-year limit. 15 days of annual training, they do not count towards the 5-year limit. PME, professional military education, generally will not count towards the 5-year limit. Skill training or retraining, that's a specific one that's called out, and it also does not count. Now it gets a little tricky on how that skill training or retraining is ordered, what type of orders it falls under, why the skill training or retraining is needed. But if they need to go to, if their career field has been abolished or it's gone away, you may see it where they need skill training or retraining that does not count towards that 5 years. So all of those up there are statutorily defined as ones that do not count towards the 5-year USERRA limit. Okay, enforcement. Enforcement goes through the Veterans Employment and Training Services. They investigate, attempt to resolve it, any USERRA claim that they receive from a service member. If unsuccessful, just like they issue a right to sue is a good way to think about it. They notify the person that submitted it. It may be referred to the Department of Justice. Very, very few cases are referred to the Department of Justice, but the Department of Justice does have the ability to enforce USERRA violations. See a couple a year. I mean, less than 5. And I'd say as a whole, there are about 1,000 USERRA cases filed each year, are the average numbers that are put out through the Department of Labor. Very, very small number compared to other statutory remedies, but keep in mind, if you're an employer in Oklahoma, you have a heavy military concentration, so you're gonna disproportionately have more cases in Oklahoma than you will nationwide, just because you have 2 active duty Air Force bases, an active duty Army post, 2 Air National Guard bases, a number of reserve posts, and then 6,500 Army National Guardsmen spread across the state. And within each one of those active duty installations, you have a mixture of Guard and Reserve. They're there as well, or as IMA. So keep those in mind. There's no requirement when these individuals file with vets so that they have to exhaust those administrative remedies first. They can reach out and retain private counsel to take care of that. And Stephanie, can you ask the audience what was old question number 4, how many cases they face a year. Okay, it should say none. Sorry about that. I was moving questions around at the beginning of this. So good to see that over half of our employers today face no USERRA issues. If you do face a USERRA issue, it's important to remember that you have your employer support for the Guard and Reserve, ESGR, and they have an ombudsman program that's available for free that can help try to mediate between the employer and the service member, the alleged wrong. And the VETS program will do the same before it turns into active litigation that gets everybody, a little bit more heated and involved in it. And also litigation costs money. And the way that the USERRA statute is written is that the individual that's bringing a claim under USERRA, they can recover reasonable attorney's fees, expert witness fees, other litigation expenses. So it's an incentive for somebody to retain private counsel because they know that they're going to get a fee award at the end to support that claim. Just like a lot of other of our protected categories have fee awards in them, USERRA is no different. So if you can engage ESGR, if you can engage vets and engage this type of mediation to resolve it before it turns into litigation, it'll be better for all parties usually, just to avoid that type of expense. Statute of limitations under USERRA, it's not codified, although we do think that based on some other cases that have come out that you're going to have a 4-year statute of limitations because that's what's been interpreted for the federal statute of limitations for many other claims. So if something adverse does happen, most likely that service member is barred at the 4-year mark. But it's important to keep in mind that they may be barred at that 4-year mark, but if it's a continuing sort of discrimination, you're going to keep pushing that statute of limitations out farther. Or if something happened 5 years ago and then they take service again and the same type of conduct happens, you're not going to be able to, you may be able to prevent that first one, but the second one is going to be barred. And they're going to be entitled to back pay, they're going to be entitled to liquidated damages, attorney's fees as we discussed. So keep in mind that there are some teeth to USERRA on the federal side about what it's able to do if somebody is successful in pursuing that claim. Okay, I brought up at the very beginning that we discussed state active duty. State active duty is different than all these orders. They're referred to as SAD orders, and service members like myself used to call it, you got sad days because the pay was so terrible because it was just your basic pay and it didn't include your BAH or any of your other protections you got when you got paid on the federal side. They've since remedied that, so they're not as sad anymore, but state active duty is ordered by the governor, and we've seen state active duty recently as the floods in Tulsa. When the floods in Tulsa happened and the levees were there and they needed repaired, we had a number of individuals deployed in response to that. And that's managed through the governor with the adjutant general and our joint task force, which is in Oklahoma City. And they were able to have a militia response to that to take care of that. You may also see people ordered to state active duty in response to the COVID-19 pandemic and to civil unrest that's taken place. Those individuals ordered underneath the authority of the governor. Oklahoma has codified a statute that gives them the same rights and protections to the full extent that USERRA does, they have underneath state active duty. So great for service members, but that doesn't apply in every state. So if you operate in more than one jurisdiction, some jurisdictions will not have a state statute on the books like that. So it's important to keep in mind that the protections that they may have in Oklahoma may not apply if you also operate in Texas, Kansas, Arkansas, Mexico, or even farther away. Just something to keep in mind. Again, state active duty order, it's going to be ordered by the governor. It's going to say state active duty at the top. It'll give the period of service, where they're going. I would encourage employers to request documentation from that, and that way you can use that. One thing with state active duty that is not entirely clear is, does it count towards the 5-year term? I would say most likely it does, because it doesn't have a specific carve out in either the Oklahoma statute or a specific carve out in the federal statute saying that if you're ordered to state active duty. Now, again, we would have to look at the order and see how it was done, but if it's a true state active duty order, it should count towards that 5-year requirement. And probably more importantly here, the Oklahoma statute, if it were to be amended someday in the future to say that it didn't, you'd have a hard time saying under, policies of supremacy that a state statute could circumvent what federal law says. So for now, I'd say it's probably okay to count that state active duty time towards that 5-year cumulative service under USERRA. 3 minutes. Okay. Okay. Briefly, RIFs and furloughs. It's important to keep in mind with RIFs and furloughs, you can, as an employer, have a RIF or you can implement a furlough. If the employee is RIFed or furloughed and then they go on duty and you recalled everybody else back, you're still going to treat that service member the same. And that's kind of a great rule of thumb is how you would treat a service member in generally under USERRA, you should do the same for FMLA or jury duty or any other type of leave that you grant. If you pay during the period of FMLA, then you should pay during the period of USERRA. If you pay for jury duty, then you should probably pay for uniform services, time that a service member's gone. And I would encourage you to have a military policy in general, just so that you can address these types of situations and you can prevent a lawsuit by saying, we have a military policy, they're well aware of it, it's in our handbook, we cover this many days and then it switches, but you don't ever want to have any type of discriminatory policies in place where you give a lot to FMLA, but you don't give anything to your service members on USERRA. I know Adam talked about, our chair of our practice group, about RIFs and furloughs, and I'm sure he said that no statute directly addresses RIFs and furloughs, short of the WARN Act for some employers. So when you develop the criteria for your RIF, just make sure that you're not singling out individuals that have been gone on protected leave, like USERRA. Make sure that you're doing it on seniority or skill set or department, and it has nothing to do with it. If you decide to furlough while that service member is on qualifying military leave, that is okay. Just make sure that you're furloughing similarly situated employees, and that if you decide to bring them back off that furlough, you do the same for that military employee. Just essentially treat them the same. So, and that reemployment, if it's a long time that they're on it, and you treat it like you would the escalator principle too, like if you were going to call them back, where they would have been if they moved up or if they moved down on those positions. Just make sure that you reemploy them to the same status with the same seniority that they had before, with the same benefits that they had before, almost essentially treating it like they were never gone in the first place. If you treat it like that service member was never gone and where they would have been, then you have a much more defensible position with regard to the actions you took for that RIF or that furlough. Okay, so I know we briefly touched on that. Keep in mind, you also have affirmative defenses under the statute you can raise, either a change in circumstances, undue hardship, saying that the position was temporary. If you have an injured service member, you have a duty to try to find them a position that they can either work with that injury or retrain them into a new position that's similar to that old position with all the same benefits and statuses and everything else to rehabilitate them. But if you can't do that, that is one of the affirmative defenses. Just keep in mind that, as with all affirmative defenses, the burden is on the employer, and that burden is very hard to overcome. So Stephanie's giving me the nod that we're supposed to take questions now. And okay. And I guess that those ones you wanted to pull up. Will you pull up number 10? What number is that? 10. Okay, Stephanie. This is a perfect example of an all of the above, that wildfires in California I touched on, you have people there. COVID-19 response, you had the president order that special funding would go out so that the governors could have people available for that. Airdrops of hay in western Oklahoma to cattle during a drought. I put that one on there, and I like the one person that answered that because that actually happened. When we had severe drought, we used our C-130s to drop hay to cattle there so that the farmers that had operations there, they wouldn't lose their entire herd of cattle that year. Flooding in Tulsa, we briefly touched on, that was just last year. Search and rescue following the more tornadoes, that again happened. Unfortunately, the National Guard's been called up every time we've had tornadic activity for those types of responses. So, okay, so briefly touching on some of the protections against discharge that service members will always have. If they go on qualified military duty, you can't discharge them without cause. So an exception to your at-will employment doctrine for 6 months if their absence was between 31 and 180 days. So if they were on qualified military service for 31 to 180 days, you have an exception to that will employment doctrine that it has to be for cause termination during that time. If they were deployed or they were on their qualified military service for more than 180 days, then they have 12 months of termination that can't take place unless it is for cause. Very, very rare circumstances, but if you get into a position where you're going to terminate for cause and you have a service member or somebody that's in the uniformed services, make sure that you document it very well, because you're going to have to overcome the burden that A, it was for cause termination because they have that statutory protection built into place for that exact reason. And that is a high burden to overcome, and often isn't overcome in most litigation just because it is pretty clear cut about what's going to happen. Stephanie, can you bring up question number 12? Okay, perfect. So vast majority of people have not had to work with ESGR, employer support for the Guard and Reserve, to resolve a dispute. As I've mentioned throughout this, I would highly encourage you, if you ever have a dispute you know has been filed or a dispute you know is going to happen, that is a free resource. They will also reach out to employers to offer free training if an employer wants training on this, because you do employ a lot of service members and you just want to learn more about, you know, what can be done or building that partnership in between. ESGR is available, and those ombudsmen, they're service members, but they also come from all pieces of industry. So they understand that there's always this inherent friction of having to employ service members because you know that you may lose them at any time and that it is hard on employers to be gone. So they do their best to have programs in place to help support those employers, to make sure that everything is available for that employer, to make sure that there's free resources for that employers. And if I have any service members in the audience today, you know, keep in mind that you can nominate an employer for the great things that they've done through an ESGR award and nominate everything your boss has done. And the military does give back in a lot of ways. You know, we have boss lift programs, we have letters of appreciation, we have plaques that are put up. And that's great for a service member to give back to their employer. So even if you don't want to use the ombudsman programs, you feel comfortable with it, just make sure that your employees are aware that ESGR is out there for them to reach out to their employers as well. And really recognize the great work that their employers do to support having members in uniform, members of the uniformed services in their employment. That's all I really have today. I did get, oh yes, Stephanie is telling me that part of today we're going to do a Southwest Airlines gift card for $100. Do you know who it's going to be? If you can hear her whispering, you already know, but Laura Patterson, you have won a Southwest gift card for $100 for attending today's seminar, and we'd like to thank you for that. Oh, I guess we have one more polling question that Stephanie wants to put up. Okay. Well, I would like to say that 12 people think that they're finally going to start playing defense, which it might take 12 men on the field for OU to finally get things together on that defensive line. Diehard Sooners fan. It's just been painful to watch recently. I'd like to thank you again for attending Crow and Dunleavy's webinar. We hope you enjoyed this series. As always, if you have legal questions we can help you with, please reach out to our team of qualified labor and employment attorneys and we'll be happy to help you. If we didn't answer your question today, please feel free to reach out and send us an email and we'll get back to you as soon as we can. Thanks and have a great day.